Welcome to the Standards Committee. First meeting for a good while. Let's start with the evacuation procedure. We're not expecting a fire drill, so any bells that go off is the real thing. Location plan of the exits are on the doors. On discovering a fire, please carry out the following: sound the alarm, attack the fire if possible and safe to do so. And on hearing the evacuate signal, exit the building to your nearest safest exit. Councillors will know where it is, but it's either that one or through the way you came in. Report to assembly point G in the car park and stay there until the appropriate officer, in this case Sophia, says you can leave. Because if it is a real event, you don't want fire officers searching through the building looking for them. So, right. Apologies for absence, members of our council business. Who are you substituting for, Mark? Do you know?
I'm clear, I'm only at moment.
Right. Apologies received from Councillor Jarvis, substituted for Councillor Simpson, and Councillor Barnett. Apologies from Councillor Barnett, substituted by Councillor Hobley.
Okay, so welcome to everyone. Disposal, pecuniary and non-pecuniary interests. Anyone got any? We have here with us the independent person appointed by the Localism Act. Ellen, do you want to introduce yourself so everybody knows who you are?
My name is Ellen Beattie. I'm a local resident and I'm here as an independent person. I'm fully conversant with the case today.
And we also have online Estelle Colligan, who did the investigation. Is that right?
Yes, that's right. Good evening, Chair. Good evening, councillors and everybody. I'm very pleased to be here with you this evening to talk about our investigations.
Right, thank you.
So I'm sorry I missed, but I think I ought to declare that I do know Ellen.
And so do I, yes. Anyone in Coleshill knows it. Ex-woman PC.
Retired.
Tired.
X sounds like up and salad.
I don't think that counts. You print understand. Right.
Well, that's very easy.
Only David is on.
The next thing on the agenda is to consider the exclusion of the press and the public. We would normally do that, which is why it's printed in gold pages, but we don't have to. Does anybody have a view on it? Councillor Simpson.
Actually, my only comment is that we should follow form and practice. So I think, I'm sorry I've not attended many meetings in this house, but if there is an understood method of working, then I think that is what we need to stick to as opposed to change. So if in the past that the meeting has been held ex camera, then we should do so. If it's been held in camera, then we should do so. I think we would need to have a fairly logical reason for departing from normal customary practice if that were to be the case.
So I've been told that the decision we need to make is, do we accept going into closed session or not? Hey.
I agree with Councillor Simpson. I mean, I think it depends. If someone wants to wander in, then you have a stranger that you don't want. So I mean, and then you have to explain why you're kicking them out, and you have to go through the procedure. If you go through the procedure is there, as I think it's just been explained. I think that would be the best way of doing it. So anyone who's exempt from that is exempt from that.
Does anyone disagree with what's been proposed? So we're going to accept that we stay in open session, and you need to press some buttons to make it.
And just so I can be clear, Chairman, is that what has previously been done?
Through you, Chair, we haven't had many standard committees the previous one was in exempt, in accession, we've not had many of these.
And what is the standard course in other authorities? Do they normally meet in private session or in public session?
Can I refer that question to our legal advisor, who may have more knowledge than me, please?
Stuff.
Estelle.
Yeah, thank you. Thank you, Sophia. Sorry, I wasn't quite sure whether you were referring to me then. Yes, thank you, Chair and members. So this is quite, this is an important point that you have to decide. So I have spoken to Sophia about this. So the general rule when you're dealing with reports of investigations into code of conduct matters, because of the importance of transparency and openness and the public interest, etc., the standard rule is that you would take these issues in public and that it would be a public meeting, you would talk about it in public, etc. We have redacted the reports in small part to take out some private information, but for the main, the reports are as they are. And it is right, and there is case law supporting this to say that they should be heard in public and in fact should be published because there is strong public interest in people being able to see and understand the behaviour of their elected members, both at parish level and at your level, at principal council level, when there have been code of conduct issues and when there have been findings, etc. So that is the sort of default position, if you like. But having said that, there are occasions, and there have been occasions when I've been involved as well, when for various reasons pertaining to the particular case, you would go into private session. It is also possible, although I don't think it applies in this case, if you start out in public session and something comes up that is particularly sensitive, you can then move into private session to discuss it and then reopen the discussion as again into public session. But once you decide that you're going to go ahead in public session now, if you do that, sorry, then it is appropriate to have a pause while the papers are published, so they are then public, and then you can go ahead with the rest of the public part of the meeting. If that is clear.
That's helpful, thank you. How long a pause do we need? So shall we agree first that we're going to keep this in open session? Yeah. Yeah.
I'll propose.
Any consent to that? So we're agreed it stays in open session. And they're just going to go and press a button that makes the publishes it on the web, I think, whatever it is.
And Chairman, I think all of that is logical. I'm very happy to follow the guidance we had. But I think we need to amend the rules of terms of engagement so that we don't have this conversation in future. If the standard is that these meetings are held in public, then
Precedent for that.
I think that's what we do.
Let's go.
You know, we don't need to go through a recommendation and then not do it again in future.
No, I think there may be more on the way for this one. So, right, so we're staying in open session. So we then move on to agenda item 5 to consider the report about standards investigation. Oh, I'm being asked if we can adjourn for 10 minutes until it's actually published on the. So, you know, I'll stay here for 10 minutes and talk amongst ourselves all the time. So let's. You've all had this weighty report. I guess you all had an opportunity to look through it to whatever degree. And you'll see that there is a 5-1 summary and recommendation. Can I come to Estelle, please? Do you want to introduce this report? Is there anything you want to add to the report that's in front of us? Or are you content to?
Yes. Thank you, Chair. I mean, what I was going to do, but it's entirely up to you. You might not want me to do this. Because the investigation reports are quite complicated. I was just going to talk through the main issues so that everybody understands, because I'm aware that this matter took a long time, but it was quite a complicated investigation. I'm happy to do that. I've prepared something. I would talk probably for about 15 minutes, but if you would prefer not, because you've read everything and you're confident that you understand everything, then, you know, I'm happy simply to take any questions if that's what you would like to do. I mean, the report, Sophia's report, is a very bare bones summary of the issues and the findings, and I was just going to flesh that out with a slightly fuller summary, if you would like to hear it. But I said I would talk for about 15 minutes. But if I'm entirely in your hands, Chair, what you would prefer, or committee members, what you would prefer.
So, ladies and gentlemen, how confident are you with the report that you've got? Do you have any issues that you want to sort of have further expanded, or do you feel that you've got a grasp of the issues from the report?
Well, I feel like I had an understanding, but now the offer's there, I kind of feel like we'd be daft not to, in a way, just to make sure we're all on the same page. But I'm happy to go whichever way, because I felt confident coming into this room, but now the offer's there, I'm kind of thinking I'd go with the majority. That's my view.
Other views? Andy?
Yeah, I read the report when it came out, but that is a couple of weeks ago, so I think I probably would welcome a refresh of them.
Yeah. Okay, I'm getting the sense that we'll take you up on your offer. But I think just perhaps help us through the, as you say, the key points. It needn't, as long as you need, but.
Yeah, absolutely. Yeah, thank you, Chair. I'm happy to do that. And please, you know, stop me at any point and ask me a question or whatever, and I will I will take you through it. And I think the other thing to say, I think for the people who have complained and for whom this has been a very long process, and indeed for the people who have been complained about, I think it deserves a little time. So, and I think, you know, it deserves sort of just understanding the issues and going through them a little more in detail. So thank you very much. I just want to explain, first of all, about the bundle very quickly. You may have realised this, but unfortunately that it's not continuously paginated. So following Sophia's report, you will find the arrangements for dealing with the Code of Conduct complaints, which is 6 pages. Then there is a report into the complaint by Councillor Bevan against Councillor O'Meara, which is 40 pages. Then there's a report into the complaint by Councillor Bevan against Councillor Robinson, which is 47 pages. And finally, the report into the complaint by Mr. Steve Stewart against Councillor Robinson, and that is 50 pages. So just going back over the timeline, most of the complaints were referred to us by a previous MO before Sophia's time on the 23rd of March 2023. Mr. Bevan then submitted a second complaint referred to us on the 28th of June 2023. As said in the report, Councillor O'Meara had actually resigned before the complaints were referred to us, but the monitoring officer wasn't aware of that. Councillor Robinson resigned as chair of Wateralton Parish Council on the 29th of June 2023. We then asked whether the council wished us to continue with the investigations, and this committee met on the 6th of September 2023 and decided that there was significant public interest in continuing with the investigations. So we continued. Our final reports were shared with the monitoring officer at the time, again, not Sophia, in draft form, prior to sending them out to the parties for comment. And we shared those reports in that form on the 6th of December 2023. There were unfortunately significant delays, which we think were because there was a rapid changeover of interim MOs, and there was sort of a lack of communication, lack of information left between them. And meaning that our final report was issued on the 13th of June 2024 to the monitoring officer, but the final reports were issued to the parties in May this year, May 2025. So that's just a quick explanation of the chronology of what's happened. So then if we look at the various reports, so the first report is Councillor Neil Bevan's complaints against Councillor Belinda O'Meara, and I refer to people as councillors, even though, you know, Councillor Belinda O'Meara is no longer a councillor at Wateralton Parish Council. So at the time of the incidents complained about, Councillor O'Meara was chair of the HR committee and vice chair of the parish council. In June 2022, Councillor Bevan raised a complaint about the clerk at the time. Councillor Bevan felt that Councillor O'Meara did not deal with the complaint properly, including not addressing parts of the complaint, cancelling a promised EGM, extraordinary general meeting, arranged for the 21st of July 2022, at which the complaint was to be dealt with, and not providing updates or a written response to his complaint. In late June 22, Councillor O'Meara notified Councillor Bevan that a grievance had been raised against him by the clerk, but refused to provide a copy of the grievance. He was invited to a meeting in early July to discuss the grievance, but again, Councillor O'Meara refused to provide a copy or any details of the grievance. Councillor Bevan's second complaint about Councillor O'Meara related to her handling of a settlement agreement for the former clerk, who had by this time left. Councillor Bevan complained that Councillor O'Meara led the group dealing with the settlement of the agreement, but it was not actually the HR committee and was not a properly constituted group. He also complained that he was personally named in the settlement agreement and bound by restrictions under it, although he did not see the agreement, was consulted on it, or had any involvement in it. So in considering the first complaint, the handling of Councillor Bevan's complaint against the former clerk and the handling of the subsequent grievance raised against him, we considered the situation analogous to the case of R on the application of Harvey versus Ledbury Town Council, a 2018 case. The case established that in complaints against individual councillors, the correct course of action is to deal with it under the Code of Conduct procedures. So the parish council could have handled the matter in fact as a grievance, but they should have followed the appropriate procedures under the Localism Act and the Code of Conduct for complaints against councillors, which include not making any findings without the involvement of the independent person, because that's a particular protection under the Code of Conduct procedures for councillors. There were also failures in fairness in not allowing Councillor Bevan to know the issues raised in the grievance against him and not allowing him the opportunity to respond properly. There was a complete lack of fairness in the process, and Councillor O'Meara, as chair of the HR committee, was responsible. In considering the second complaint, we found from talking to the replacement clerk, the new clerk, that Councillor Bevan had been told at least of the contents of the relevant clauses in the settlement agreement, which mentioned him, around about the 7th of December. Around about the 7th of December. However, he was not given the specific wording of the clause, nor were the restrictions being placed on him explained prior to the parish council signing the agreement. We also found it impossible to see how the parish council could bind Councillor Bevan and one other councillor who was also mentioned, or how they could be made personally liable to the clerk for any breaches of an agreement which they had not seen and were not personally party to. We also found that there were failures in the procedure for negotiating the agreement, although that did not make the agreement itself invalid, in that the group led by Councillor O'Meara was not the HR committee and was not a properly constituted committee. We found, therefore, that Councillor O'Meara had failed to treat Councillor Bevan with respect. However, although we found failures in the procedures and a lack of respect shown towards Councillor Bevan, we found nothing to indicate that Councillor O'Meara had treated him in a malicious or spiteful way, which would justify a finding of bullying. So that was the first report. And then we move on to the second report, which was Councillor Bevan's complaints against Councillor Philip Robinson. So at the time of the incidents complained about, Councillor Robinson was the chair of the parish council. It is also relevant to the report to say that the clerk at the time was Councillor Robinson's sister-in-law. Councillor Bevan's two complaints against Councillor Robinson relate to the same two issues as against Councillor O'Meara: the handling of a complaint by Councillor Bevan against the former clerk and the subsequent grievance that the clerk raised against him, and the handling of the settlement agreement with the former clerk. Regarding the first complaint, we found that although the communications about the grievance came from Councillor O'Meara, Councillor Robinson, as chair of the council, was also on the group involved dealing with the grievance. There was an invite to an informal meeting on the 30th of June 2022, and that was copied to councillors Chris O'Meara, Wendy Rees and Philip Robinson. This was not the fully constituted HR committee. As noted above, Councillor Bevan refused to attend the meeting and he confirmed to us that the meeting did not go ahead. We considered the issues set out above under the Councillor O'Meara complaint, including the impact of the case of Harvey versus Ledbury Town Council, failures in procedures and fairness, and concluded that, although the communications with Councillor Bevan were led by Councillor O'Meara, as chair and as a member of the group of councillors seemingly dealing with the grievance, Councillor Robinson had oversight of what was happening. He was copied into at least one of the emails relating to the grievance. In respect of Councillor Bevan's complaint against the clerk, we were also concerned by Councillor Robinson's involvement. He called the EGM for the 21st of July 2022, which was to deal specifically with the complaint, but it was then cancelled with no explanation. There was reference in emails to advice awaited from the Warwickshire and West Midlands Association of Local Councils, which never transpired. The advice never appeared. We found that Councillor Robinson, as chair with overall responsibility, failed to treat Councillor Bevan with respect. Regarding the second complaint relating to the management of the settlement agreement, Councillor Robinson formed part of the small group named above, who negotiated and dealt with the agreement. Again, there was a failure of proper procedure. The group was negotiating the agreement without being properly constituted or having delegated authority from the parish council. Councillor Bevan was named in an undertaking in the agreement without being properly made aware of it and without being party to the agreement. As chair, directly involved in the negotiation, we found that Councillor Robinson was also responsible for failing to treat Councillor Bevan with respect. We also considered the issue of Councillor Robinson's non-disclosure at the various meetings to discuss the agreement of his interest as brother-in-law of the former clerk. We considered this under paragraph 13 of the Code of Conduct relating to disclosure of other interests, which includes the requirements to disclose personal interests which are relevant to the item under discussion. There was no record of Councillor Robinson ever disclosing his interest at any of the parish council meetings where the agreement was discussed, or of absenting himself from the discussions. We found, therefore, that Councillor Robinson should have declared his interest at these meetings and should not have participated in or voted on the matter. We also noted that he signed the settlement agreement despite his personal interest. We consider that Councillor Robinson's behaviour was a clear breach of the Code of Conduct in respect of declaring interests. We also found that Councillor Robinson's behaviour in involving himself in the process to deal with Councillor Bevan's complaint against the clerk and the clerk's grievance against him, and in the settlement agreement, was a breach, was a breach of paragraph 3 of the Code, seeking improperly to confer an advantage or disadvantage on any person. However, for similar reasons to those above set out about Councillor O'Meara, we did not find that Councillor Robinson's actions were a breach of paragraph 2 bullying under the Code. So finally, and I am nearly there if you'll bear with me, the third report about Mr. Steve Stewart's complaint against Councillor Robinson. The other two reports were quite complicated, but this was slightly more complicated, I'm afraid to say. So Mr. Stewart was co-opted onto the parish council in 2017 and decided not to stand again in 2019. At the time of his complaints, he was complaining as a member of the public. However, he rejoined the parish council on the 4th of May 2023, and showing on the website, he is currently chair of the parish council. So Mr. Stewart complained about 3 issues. 1, the failure of the parish council to adopt a proposed environmental policy, which he had progressed during his time as parish councillor in 2017 to 19. 2, the failure of the parish council to finalise the application for the dog inn to be registered as an asset of community value. And 3, issues around links between the parish council and the local school. Mr. Stewart did not say which parts of the Code of Conduct he alleged that Councillor Robinson had breached, but we considered the issues of respect under paragraph 1 and also the issue of seeking to improperly confer an advantage or disadvantage on any person under paragraph 3. So in relation to complaint 1, in respect of the environmental policy, it appears that the parish council did review Mr. Stewart's version that he'd left with them, but decided to adopt a different version of the policy which did not contain Mr. Stewart's proposals. In his evidence, Mr. Stewart disclosed emails between Councillor Robinson and the clerk, in which Councillor Robinson refers to Mr. Stewart in a pejorative and dismissive way. We found that these communications showed lack of respect towards Mr. Stewart, a member of the public, and amounted to a breach of the Code of Conduct. However, we found no issue with the fact that the parish council had not accepted Mr. Stewart's proposed policy. The adoption of a policy is a matter for the parish council at the time. There was also no issue in the fact that the parish council had only published the agenda at the meeting where they adopted the policy without supporting papers, including the proposed environment policy. We explain in the report that, although some parish councils choose to publish all supporting papers with their meeting agendas, they are not actually legally required to do so, unlike principal councils who have more strict requirements about publicity of information. So in respect of the second complaint, the dog inn and the failure of the parish council to finalise the application to register the pub as an asset of community value, we found no breach of respect, and we also found that there was insufficient evidence to find a breach of improperly conferring an advantage. It was clear in the evidence that an application had been made in 2017, but that neither Councillor Robinson nor the clerk could find any information about it on your website, on the NWBC website, when they were looking for it in 2021, following Mr. Stewart's request to them to pursue the application. It was clear that neither Councillor Robinson nor the clerk knew what had happened to the application. We found therefore no evidence of a breach of respect and could not make a finding about the issue of improperly conferring an advantage because of lack of evidence. So complaint 3, which was the more complicated complaint, this complaint related to events around the links between the parish council and Water Orton School, the local school. When Mr. Stewart had been a councillor, there had been a space on the school board of governors, and it was suggested that a parish councillor should sit on the board. Councillor Stewart took on that role. After he left the parish council in 2019, another parish councillor took on the role, but subsequently resigned, both as a parish councillor and a governor. Mr. Stewart emailed a few times to the parish council to suggest that he could take on the role voluntarily, although he was no longer a councillor. He also suggested exploring financial efficiencies through the school and the parish council working together. We reviewed a series of email exchanges between Mr. Stewart and the clerk, in which the clerk politely said that his request came too late for the next parish council meeting, but that she would put it on the next meeting after that. We commented in the report that, although Mr. Stewart was unhappy about the clerk's reply, it is usual for matters to be put to the whole council for a decision. The parish council held an EGM on the 9th of November and invited Mr. Stewart to speak to that meeting. We found that this was the correct procedure and we found no breach relating to this particular issue. However, following that meeting, Mr. Stewart sent an email addressed to whom it may concern to the clerk, suggesting corrections to the minutes and pointing out some misinterpretations of the standing orders. Mr. Stewart attended the next council meeting on the 25th of November, and there was an exchange of words and there was a bit of a heated argument between him and the clerk. He alleged that the clerk shouted at him and said that to address an email to whom it may concern was inappropriate, and that it was also not for non-councillors to question minutes. She also, he said, humiliated him in front of his 6-year-old son. Mr. Stewart then sent a series of emails to Councillor Robinson complaining of the clerk's behaviour and asking Councillor Robinson to deal with his complaint informally with the clerk. There was a subsequent conversation between Councillor Robinson and Mr. Stewart, and Councillor Robinson said in that conversation that they should meet, the two of them, to discuss the issue. But Mr. Stewart alleged that he received no further information about that proposed meeting. Councillor Robinson did not respond to a number of his emails until on the 30th of December, when Councillor Robinson said that he would speak to the full council, but asked Mr. Stewart to deal with the matter simply as an emotional outburst at the meeting and nothing more. Mr. Stewart complained formally on the 30th of December 2021 about Councillor Robinson and the clerk. There were then a series of emails between Mr. Stewart and Councillor O'Meara, chair of the HR committee, between January and July 2022. Most of these emails are Mr. Stewart chasing for updates and not receiving a reply. On the 31st of March 2022, Councillor Robinson made a public statement at the parish council meeting and said that the HR committee had spoken to both parties about the complaint and decided that no further action was needed. Subsequently, Mr. Stewart emailed asking for proper replies to his correspondences in May and June. Councillor O'Meara replied to say that she had sent him 2 letters, but she had in fact only sent him 1 in February 2022. Despite Mr. Stewart's subsequent emailing several times, he received no further reply. We found a number of failings with Councillor Robinson's handling of Mr. Stewart's complaint, including the following. There was no proper complaints process, and it is unclear what process Councillor O'Meara or Councillor Robinson were following. Councillor O'Meara sent an unsigned response to Mr. Stewart on the 9th of February 2022, followed by an amended signed letter in the post that was dated the 6th of February, but postmarked the 21st of February. There was the failure of the parish council to answer Mr. Stewart's questions and the missing second letter, which he never received. Despite identifying that she had a conflict and should not deal with the matter, the clerk continued to respond to emails from Councillor O'Meara about the complaint, even correcting a draft letter. Despite Councillor Robinson saying at the parish council meeting on the 31st of March 2022 that both parties had been spoken to, no one had spoken to Mr. Stewart. We found, therefore, that Councillor Robinson showed a lack of respect towards Mr. Stewart in 1. Failing to deal with the complaint against the clerk correctly, 2. Not arranging a meeting in December 2021 with Mr. Stewart, despite saying he would, and 3. Incorrectly saying that both parties had been spoken to at the council meeting on the 31st of March 2022. We also found that Councillor Robinson tried to minimise the complaint against the clerk and or make it disappear, possibly because of the family relationship between them. He also failed to refer the complaint against himself to the monitoring officer, which was the correct process. We found, therefore, that if Councillor Robinson had still been a councillor, he would also have been in breach of paragraph 3 of the code, improperly seeking to confer an advantage or a disadvantage on anyone in that we felt that he was trying to protect the clerk in his actions. So that, you'll be pleased to know, members, concludes my summary of the 3 quite complicated investigations, and I'm happy to answer any questions that you might have. Thank you very much.
Thank you. Are there any questions? Mark?
Thank you, Chairman. There are various elements of these reports which have been redacted. I'd like to know why.
Yes, thank you very much. That's a very good question. There are issues that have been redacted which don't relate to the sense and the meaning of the report. They just relate to comments about the health of various individuals. And there were particular detailed comments which I thought was inappropriate if this meeting was held in public for it to be broadcast, because the individuals are named. So it's obvious who would be being talked about. If that helps.
I'm not sure it does, to be honest with you. As the Standards Board, I genuinely don't think that we should have reports that have got anything to be said. If it's not germane to the issue, it shouldn't be in the report to begin with. And if it is germane to the report, then it shouldn't be redacted. I know I'm being black and white, but it's the Standards Board that we say anything.
I think we have to go with the advice that we've been given on this.
But I'm deeply uncomfortable with a report to the Standards Board having elements redacted.
Noted. David, did you want to comment?
No.
Anyone else want to ask anything or say anything? In which case, Estelle, thank you very much indeed. We will take it from there. Anything else you need to add? No? Ellen, anything you want to?
No, that's be very clear. Thank you very much.
Okay. So looking at the report in front of us, page 5.1 onwards, we have three fairly simple recommendations to us. Reflect the situation in front of us. First, to receive and note this report and its appendices. Second, to agree to send the reports and information to the parish council. And my understanding is it's up to the parish council what they choose to do. And third, to agree to take no further action on these complaints, the reason that the people involved are no longer parish councillors. So we don't actually have any power to do that. But Katie, you.
Yeah, thanks, Joe. I'm happy to go with the recommendation. It's, you know, going through the report and taking Estelle's extensive work into consideration. I think parish councils, like I've said before, do such a fantastic job in our communities, and they do it free of charge out of the goodness of their own hearts. You are going to get these situations. Let's just hope this is a on record public reminder of the Nolan principles that we sign up to as councillors for all of us. And just to note that the reason why we can't actually take any action here is because the people are no longer councillors. So for the amount of time that this has been going on, I feel like the outcome could have been different if the communication was better on it. But I am happy to move the recommendation, Chair, if that's okay with you. Thanks.
Thank you.
Thanks, Chair. I just wanted to sort of make public some clarity, if Estelle wouldn't mind just sort of adding lib here. If the people named, because we've just identified that it's difficult to take action because they're no longer councillors. So I guess what protection for the parish council would there be should they decide to stand again in an election or be asked to be co-opted, in regard to anything that sits on a file, or is that not a thing? Could we just have some clarity on it, please? Thank you.
Thanks very much, Councillor. Sorry, Chair.
Asking you if you have a view on that, please, if you want to comment on that.
Yeah, thank you. So yes, it's a very good question, and it's often one which comes up in these situations. This is one of the reasons why there's been commentary and case law about the importance of making these reports public, where there are findings of breaches or where people have, you know, resigned from office, but, you know, it's important for this information to be made public, because when people take up the role of councillor, their role should be under scrutiny and they should behave with the utmost integrity, follow the Nolan principles, all that sort of thing. So, you know, unfortunately, once people are no longer councillors, you can't take any formal action because the code of conduct, the actions under the code of conduct can only be made against councillors. However, in publishing reports, the information is there so that if they wanted to stand again or come forward to sit on the parish council, those on the parish council and other members of the public can see these issues that have happened before. Unfortunately, you know, one can't prevent people from standing even when findings have been made against them, whether that would be for yourselves in a borough council, a principal council, or a parish council. The legislation just isn't there for that. But all it does is it makes public these issues so that people are aware, if people stand again, that these issues have happened in the very recent past. So, you know, that's the situation, and that is one of the reasons why it is important to make these reports public.
Emma, do you want to come back?
Can I come back on? Yeah. Thank you. Thank you for that. Is there any way that if a similar issue was, if they were to be elected or co-opted, despite the public being aware of the reports, and a similar offence, let's call it for want of a better word for now, were to happen, would there be any way that previous history could be used in a standards committee going forward, or is that once this has gone today, that's it sort of thing? Do you know what I mean?
Yeah, I
Thank
do
you.
know what I do what you mean. I know what you mean, and yes, that again is a very interesting question. The standard answer is unfortunately not. It's not like previous convictions in a criminal court, and it's not meant to be like that, because as somebody quite rightly said, parish councillors are volunteers, and they come forward, and they shouldn't be sort of excessively punished for things that go wrong. But so sorry, to answer your question, if somebody were re-elected or co-opted again and something happened, you would have to deal like that as a fresh complaint. So you can't actually formally take into account issues that have happened when they've previously been a councillor. But again, the mere fact of the report having been made public and been out there would be a bit of a red flag, if you like. But you can't actually formally take into account that similar behaviour happened 2 years ago when they were previously a councillor. It couldn't be carried forward into a fresh complaint, no.
Thank you.
Right. Councillor Humphries first, then Councillor Hoffman.
I was going to say, this has gone on for a long time. There's obviously exceptional costs that have come towards it, masses of officer time, etc., etc. Who bears the cost of this? Is it the borough council, or does it get put back to the parish? Parish, if he said, she said, it's gone on for on and on and on and on, and by being extended, the cost goes even more. So where does the cost come?
Unless I'm advised otherwise, I believe the Borough Council has to shoulder that cost. Councillor Hoffman next, then Councillor Shields.
Thank you, Chair. I don't know if you can take a hypothetical question, Estelle, but as we are, I've said I'm in agreement that we take no further action, but what would the action be if, to go on the public record, what would the action, the outcome have been should the previous councillors had still been councillors?
Yeah. Thank you for the question. So you have a set of arrangements which sets out how you deal with investigations, what happens if there's a breach and somebody's still a councillor, and the standard, it sets out in your arrangements, and also the standard way of doing it, which lots of councils do. If it's serious enough and the investigation finds that there were breaches, which were in this case and quite serious breaches, I would say, is that you would have a formal hearing. So you would have a formal hearing. There would be a panel of members, and the investigator, so me or whoever, would present the report, a bit like today, but in a bit more detail, going through all the issues and the evidence. And then the subject member, so the councillors against whom the findings have been made, would be invited to come and make their representations or say what they had to say. And then it would be for so our report is basically the recommended findings, but you can't actually make those formal findings unless you have, unless, say, for example, the monitoring officer accepts them, or you go to a formal hearing, and it's the formal hearing that would be making the findings. That's why I've said in the report, if they were still councillors, these findings would be recommended or, would be made. So you go to the hearing, it's quite a process, and then you make findings, or you don't find in favour, or you do find in favour. You make those findings, and then there are a number of sanctions, which can be, well, because they're a parish council, you would have to make those recommended sanctions to the parish council, and it would be for the parish council to impose them. But normally the parish council, doesn't sort of, doesn't go against what the principal council says, because you are the arbiter of the investigation, if you like. So you would make a number of sanctions, and they are listed in your arrangements. And if I pull them up before me, I can tell you what they are. And unfortunately, the sanctions are not particularly onerous. I always say that the punishment is more going through the process. But let me have a look. We find the arrangements, find the sanctions. Let's have a look. Here we are. So what sanctions can be imposed? So official censure or reprimand, and that's normally a letter signed by that'd be signed by the full parish council. Publishing the findings in respect to the member's conduct, so doing like a press release or something like that. Recommendations to the members group leader, but that wouldn't really apply to a parish council, that they're removed from any of the committees or subcommittees of the council. There could be a recommendation if they sit on a committee of the parish council that they're removed from that committee. Recommending that the member be removed from particular responsibilities, requiring the member or the parish council member to engage in training, go on training. That's often a popular sanction. Recommend to the parish council that the member be removed from all outside appointments, any of those that they've been appointed to. And this is one that is not very often used. Withdraw or recommend to the parish council that it withdraws facilities provided to the member of the council, such as computer, website and email or internet access, or excluding or recommending to the parish council that they exclude the member from council's offices or other premises for a period of time, it normally is, except for turning up to meetings. So those are the sanctions that you've got in your arrangements. And I don't know whether you're all aware, you may well be, that there's been a lot of controversy about the fact that sanctions are quite weak. And so we are awaiting, as we speak, an announcement on code of conduct revisions and updated sanctions from central government, but it hasn't been issued yet. There would need to be amended legislation, all that sort of thing. And so we're sort of hopeful that by Christmas some information will come out about that, about improvements to sanctions that can be imposed. Because not, I'm not saying that in this situation these sanctions would probably be sufficient, but I've dealt with cases and my colleagues have dealt with cases where there's been really serious behavioural issues going on, really, really bad stuff. And there's nothing really serious in terms of sanctions, even following a hearing, that can be imposed. For example, you can't remove a councillor or suspend a councillor from the role of councillor, say for 3 months or something like that. You just can't do that because that's seen as sort of interfering with the democratic process and all that sort of thing. But there are other issues that could be done. And as I say, central government seems to be still in the process of formulating its views on that, but we are expecting an announcement about it, hopefully, in the next few months. So I hope that's clear. I haven't rambled on too much.
I'll come back.
Yeah, sorry, thank you. Thank you for that. I really appreciate it. And just again, to put on record, I can see from everybody's faces in the room, thank goodness that the taxpayers of North Warwickshire Borough didn't have to go through all of that rigmarole, which I can imagine would have cost more than £30,000 more plus that for essentially a post on the website. So I feel your frustration, and let's just hope we can all learn from this from the future. So thank you.
Councillor Simpson.
Thank you, Chairman. I think some of this is dealt with already. I mean, the report makes it clear that in the 2017 case of Hussain versus Sandwell Council, there was no prospect of sanctions. And we were doing this presumably in the interests of general good governance and the wider public interest. So we never had. We were talking earlier on, I think, about the Nolan principles, and I did check, because I'm a bit rusty on what they all are, but the first of the Nolan principles is selflessness, which talks about acting in the public interest. To an extent, I'm happy enough with the recommendation, insofar as they go, but they don't go far enough. I think, as I think was mentioned, recommendation 3 to agree no further action on the complaint. I don't see we have any alternatives, but I would like to see something that says why we are taking no further action. And that is simply because there is nothing we can do because of the passage of time and that these individuals are no longer councillor. I don't think that's an unreasonable extension. But if we go back to selflessness, I fundamentally do not believe it is in the public interest to spend £29,000 on a complaint that related to actions undertaken in 2022. Complaint was made in 2023. The initial findings were with us in 23, and the final findings were in 24. How is it in the public interest that it's taken so long and cost so much money? So I would like to see something else in the recommendation that says, how are we going to do this better? Because this, frankly, Chairman, is simply not good enough.
Well done. Right. I hope that the report, which we, with your help, is being made public, explains in the next few pages exactly why we're not in a position to take any further action against the individuals concerned. I think you're right to point out that process has taken far too long and maybe even exacerbated the costs in doing so. I think, well, Sophie is the fourth monitoring officer to be involved in this, and at least she's brought it forward for determination tonight. And I think she's well aware of the difficulties that delays have, not just for the council in processing it in its cost, but also for those involved in the things itself. And I think she's very well aware that speedier process is required for those future complaints. That nodding vigorously here, so I think we have that. I think your points are well made. I don't necessarily, but personally, I'm content with the recommendations they are. If you want to propose an amendment, that's a matter for you.
So if I paraphrase Chairman, what we seem to be saying is my points are well made, but we're not going to do anything about it.
No, if you would listen, we are doing things about them, which is why I don't think we need to add them. But it's up to you if you want to propose an amendment.
And Chairman, yes, I would. I'd like a further, as number 4, I'd like a further report explaining exactly what we are going to do differently. Now, I accept your point. Yeah, it could be that this is the 4th monitoring officer, and therefore, if we had one monitoring officer throughout that period, then we wouldn't have done it. But we can't control that. There needs to be a better process internally to ensure that these things are addressed in a timely fashion. For these complaints and for the public to have confidence in standards, it has to be contemporaneous. 3 years after the event is not contemporaneous.
So legal processes are really contemporaneous, but I'll take your point. Councillor Turley, do you want
Yes,
to?
my question would be, once the outcome that these people named had resigned or retired from their posts, surely the investigation should have been drawn to a close, that unless it was a civil reason, then there should be no further action taken, because we can't do anything here. We're sitting on our hands talking about something we can't do anything about.
It's going to the public domain.
Yes,
And still it's in the public domain, yes, but
the people
to be
involved,
candidly honest, we're talking about something we can't do anything with and can't do anything about.
but the people involved wanted some closure on the issues that they've raised and everything. So I guess
Okay, so we're going, so, okay, yeah, okay.
but yeah.
Yeah, thank you, Chair. I concur with Councillor Simpson, and I would like to see a little bit more detail on how we can tighten up the process. I appreciate what you said as well about we are restricted a little bit by process. You know, legal processes aren't known for their quick resolve, but to discuss also about Councillor Turley's, you know, idea, I totally get that, but to show good governance, I think we do need to see it out for the public to understand why we've spent so much money, to give the people involved a fair shot at, you know, their say, for want of a better word, and to show that due process was, you know, considered. But going back to the comment, it is a lot of money for what? And I think that we do need to be very clear. You know, will the public have confidence if they relate the timeline to the outcome. And I think that, you know, the clarity of stating the four monitoring officers that we're bound by, you know, we can't do much about it and so on. But also to add in that we've seen out the governance process and we've identified that the process needs to be tightened up and we will look to be better in the future. I think all of that would be quite a reasonable summary in my opinion. Thank you.
So can I Katie, are you happy to take on Mark's amendment as part of your proposal?
Yeah. Yes, Chair, sorry. Yeah, I think it's a great point. My only worry is how much money is that going to cost? I feel like it's cost a lot of taxpayers' money. But I mean, I'm happy to go with the.
If I understood Mark correctly, and I say these with great caution, if I understand him correctly, he's asking. Your job or her job?
No, Estelle's got.
It's not hand up.
Oh, sorry, Estelle. Yes, sorry, I missed you.
No, don't worry, Chair. If I may just jump in, slightly sort of just a point to perhaps help in future. And I have mentioned this to Sophia. Your arrangements, which set out how you deal with code of conduct matters and how you deal with investigations, are fine, but I think they could do with a bit of amendment to deal with this sort of issue. And it's a common problem for local authorities where you have an investigation that starts and then people resign and they leave their post as councillor. What you do then and what your thought processes are and how you might deal with them, because there may well be occasions either way, there may well be occasions as you decided where it was in the public interest to continue. And I know that the complainants in this case were very keen to have an outcome, you know, because they had suffered through this and they felt it was important. They wanted there to be a proper outcome. So you took that decision, and that was quite properly a decision you can make. In other circumstances, it might be right to actually say, okay, these people have resigned. We're not so far in the process, or the issues are not that serious, cost, proportionality, all that sort of thing. We're going to end proceedings at this point. And I do know another council that we do quite a lot of work for have recently amended their arrangements in quite detail to actually pick up on these issues, so that when it happens, you have a process to look at and you can say, okay, this is what it says, this is what we're going to do. And I think that would help you in future.
Thank you. Yeah. Okay, so Mark, wording, are you happy with the amendment, the monitoring officer to review the arrangements and bring it back to the standards board?
Yes,
Good.
but I would like it to be sooner rather than later.
I think that's taken as read. Councillor Humphries, do you want to?
I was just thinking resolution, which Councillor Turley said, the resolution, they've won the argument when the people have resigned as a result of it. There is a closure at that point, and I would have thought. Yeah. And it may be that there could be a better closure because it goes on, but then you just have to keep piling money in the pot until you get to this point.
Well, let's see
I
what
am concerned about the costs.
review that it brings back to us. We've got a proposal as amended by Mark. Is that seconded? Emma seconded, yes. Is there any other recommendations, or are we happy to vote on that one?
Can you clarify the amendments, please?
So the only recommendation is 1, 2, and 3 as printed, and 4 as I've just read out from Sophie. Okay,
Yes.
that's it. All those in favour to show, please. That appears to be unanimous, is that? I'm assuming unanimous. Thank you very much indeed.
Thank you.
The meeting is closed.
Thank you, Chair. Thank you, members.
Thank you.